There we are. So week 6, First Nations peoples and the courts. We have just returned from the break, and I was just mentioning that this is a time of year when most students are starting to feel the pressure of all of the assignments piling up, but also the end of the year coming closer, with Christmas and all of those things, and that can be a very stressful time. And I think if there's anything that I can do, let me know. It is one of those natural things that just tends to happen. And I think the advice that I would have is managing time wisely. And if you feel like you're really stuck and you need more time, I would reach out to all of your unit coordinators and discuss that with them. Because we are often happy. Well, I can't speak for everybody else, but most people that I've worked with in criminology are happy to provide extensions of time. I certainly am, if there are legitimate reasons that you'd like to discuss with me. So there are quite a few outstanding pieces of work for this unit. So let's have a talk through those first. This is just a little summary of where we've been. So summary so far, we did the intro cultural competency, the history wars, we looked at disadvantage and marginalisation. We've talked about the law, we've talked about policing in the week before the break, and now we're up to courts. So that's where we're at. Assessments, your first workbook is done. There were only a couple of people that didn't submit. So most people submitted that, which was really pleasing to see. I have had a look at quite a few of them and they're on the right track. So they will be coming out next week. Then quiz 1 is done. Hopefully you didn't find that there were too many surprises in there. The questions, I think there was one question that tripped most people up where you had to select all of the answers, and it was all of the above are correct. And so that one got a few people. But hopefully, like I've looked at the average marks, and I think everybody passed, from memory, everyone passed. Most all people got above a 65%. There were a high majority of people that got in the 8s. So, in the 8 to 9 range. And then there were about a handful of people that got between 9.5 and 10 out of 10. So most people did really well on that, which was good. The second quiz is coming up on the 26th of September. So we are the 22nd of August now. So there's a few weeks before that one, a month before that one. You're working, they're out of order, but back from that, you've got your second workbook as well, coming up on the 27th of September. So if you did make any little mistakes or errors, or there's something you can improve from workbook 1, you'll be able to implement that for workbook 2. Your annotated bibliography is due on the 2nd of September, so not next Monday, the Monday after. And today we're going to do an activity which directly feeds into that assignment. So you can check your understanding of what an annotation is. We're going to have a bit of a practice today. And then just so that you're on the right track and understand what you have to include for that assignment. And then that feeds into your research essay, the bigger piece. Now, I will cover the research essay in more detail. There will be activities that we'll do in the subsequent workshops on that. That is due the 4th of October, so the last thing that you have to do there. Any questions on any of that before we move forward? No? Okay. All right, courts. Let's get into it. So just to set a bit of the scene, so to speak, background and context to courts and this discussion of First Nations peoples and the courts. What I would like you to take some notes on are due process rights in Australia. What are they? So keeping in mind that some people, criminology is not their prominent area of study, or perhaps if you have studied it before, might be something that you've forgotten. So what are due process rights and why are they important? So in the next 5 minutes, have a look. You can Google if you like. You can use AI to generate the response and write it in your own words then after that. Whatever you do, take some notes and we will then share as a group. Okay, I'll leave you to it. And I'll turn my camera off because I am going to quickly have something to eat because I've come from back-to-back commitments. So I'll be doing that. Yeah, I'll leave you to it. Okay, so there are quite a few different due process rights, so maybe we'll just start bit by bit with one at a time. Someone tell me someone give me an overarching statement that would describe generally what due process rights are before we go through each of them. What are they?
Go, if that's okay.
Go, yeah, you go for it. Yeah, of course.
So I found a website online and it said that due process rights are the requirement that all legal matters are resolved according to the rule and principles and that individuals must be treated fairly. So what I got from that is the idea that no one's above the law
Mhm,
and that the law should be fairly applied.
mhm. Yep,
Um, and then I thought of like precedents, I think it's called precedents.
precedent. Yeah,
Yeah, and the fact that um the law is basically just precedents. I don't know. Um,
like
yeah,
a
I don't
reflection of decisions that have come before, and
yeah.
yeah. So
Yeah,
precedent referring to that, the outcome of matters previous has an impact on, and guides subsequent
yeah.
matters. So you can say, based on this case that happened before, that's relevant to the current case.
Yeah, so everyone's basically being treated fairly
Yeah,
within the
supposed to be, I think is the,
supposed to be, yeah.
yeah, yeah, is the key. You've absolutely captured it, Talara, that, it is the due process rights are the rights to fair treatment, equity, equality in the eyes of the law through predominantly the court trial process. There are some due process rights that will cross over into the topic from the week before the break of policing in terms of how police execute their powers and use their discretion and what they can and can't do. Um, there is some of it that crosses over into the correction space, or more so custodial space, in terms of people can't be arbitrarily detained. So there are some that relate to other arms of the criminal justice system. But if we look at what those due process rights for upholding fairness for a defendant in a criminal trial are, what are some of the aspects that you came across?
Right to legal representation,
Yes.
um,
Yep. So
uh,
adequate legal representation. Yep. Um,
yeah,
What
presumption.
Oh, we might do one and then let's answer the second question for that one. I think that's probably the easiest way to do it. So if we take the right to legal representation, why is that important?
Because everybody that goes through the criminal system should have the right to uh, a knowledgeable professional who can assist them with
Yeah,
their case, because obviously not everybody's an expert in law.
yeah.
And unless you have somebody that's batting for you, you can be you can get an adversarial outcome.
Yeah, absolutely. So the court process and the jargon that is used is very hard to understand. And so that representation from an expert that understands the law, but not only that, who is exposed to the court process and understands all of the little nuances of the procedural, aspect of it, and what all the words mean is very, very important. Yeah. What else do we have?
Right to be informed of charges.
Yeah, absolutely. Yeah. So, right to understand what you're actually being charged with. And then if we feed that into the court process, it's then that can tie into things like disclosure of the evidence, not only the charge, but then subsequently what evidence is being presented, so that the defendant has the ability through hopefully their legal representatives to construct their case or their side, even though the burden doesn't fall with them, it's on the prosecution in a criminal trial. It's important that a defendant understands what's going to come up. But yes, step before that would be, firstly, what are you actually charging me with? What else?
Presumption of innocence.
Yes. Yeah. So presumption of innocence, innocent until proven guilty, which is a really interesting one when we look at some of the practices that are used. If we look at remand, for example, that flies in the face of that directly. So I think that's a really interesting one to unpack, and we'll unpack that in a moment. What else?
Right to impartial jury.
Yes. So we know that in most cases, unless it's a judge-led trial, it will be a trial by our peers. So peers being a representation of the community. There are a vast array of issues around jury selection. And we are going to use that as our focus topic at the end for the annotated bibliography and look at what are some of the issues around First Nations representation in juries. Good. What else? Anything else?
Right to present evidence.
Yep. Yep, right to present evidence, the right to cross-examine, and this ties back into Natalie's first point around legal representation, that when somebody is self-representing, those are very, very difficult things to do. Yeah. Right to appeal is another one. What else have we got? I've mentioned arbitrary detention. Right to a speedy trial is an interesting one as well. A timely trial that avoids prolonged detention without resolution. And one of the issues that I'd just like to flag there, we won't actually talk about it in great depth today, but is people, and I think I've mentioned it before, people who are found unfit to plead. So on the basis of usually intellectual disability and lack of capacity, they are detained indefinitely until such time that they could plead. And that's a huge problem. Yeah, but we won't talk about that today. The Unfitness to Plead project is something to look at in Australia if you are interested in that. Yes, so due process rights come from the Constitution, they come from common law, and we would hope that they are upheld for most everyone, but obviously, as we're talking through these things, you're probably already starting to see the cracks in the system. We are going to talk now about some of the issues for First Nations peoples in regards to this. So with due process rights, when they are not upheld or when there are barriers to those, we talk about a concept of access to justice. So it is through due process rights that people access justice. If they don't, then their access to justice is said to be blocked or impeded. So when you see that prompt for the research question around access to justice, this is the realm of sort of subject matter that it's talking about. So we are talking about more of this focus on the courts, the procedures and things like that. So thinking about access to justice, we've got a number of discussion questions here. And I'm going to break you off into two breakout rooms. We won't go for too long in the breakouts because I know that some people don't overly enjoy the breakout rooms and would prefer a bigger group discussion. So we can do that for probably 10 minutes in the breakouts and then we'll come back. But I want you to discuss the main challenges faced by First Nations peoples in the court system. So in trying to access justice and in trying to access those due process rights that we are all entitled to, what are some of the challenges? How might that be linked to historical and socio-economic factors that contribute, like the things that we've talked about before with disadvantage and marginalisation? That's okay, Craig, no worries. And then what are the potential biases within the court system that affect First Nations people? So have a discussion of that in groups and then we'll come back to a broader discussion. So let's go for 10 minutes. So what are we, 12:36-ish, and then we'll discuss. Does anyone have any questions about the question? Clear? Yep, awesome. Very good. All right, I'm going to disappear and I'll pop you into breakouts. Here we go. Moving forward. Craig's got a little visitor joining us. Lovely. Never too young to start them on the learning journey. what issues, challenges did you talk about in your groups?
We focused on the socioeconomic disadvantages,
Yeah.
such as poverty and unemployment, which drive all of the main challenges in the court system, which then lead to the which also is cause of the historical and socioeconomic factors, and then also contribute to the biases. Talking about political powers and those that maintain those positions of power and authority continue to enforce these language barriers by lack of funding, lack of recognizing research, ensuring that the research fits their agendas, which keeps them in their positions of power, disregarding cultural knowledge, limiting resources, and it contributes to the over-representation and disproportionality of Indigenous incarceration. When we look, so we focused on looking at how a lot, when you consider they're incarcerated on minor offences, very rarely on criminal. So, for example, fines, unpaid fines, that's that whole socioeconomic disadvantage situation of being in poverty, uneducated, not having the means to pay these fines. And so it's this perpetual cycle. And that's also based on that historical systemic racism, I think that Sabrina was talking about. That it just, when we looked at the political agendas of why, where, and how, when we look at our current system, it's evident that the system doesn't work because there's continued and higher overrepresentation today than there was previously. So that's an indication that the system doesn't work. But what does work is the money that gets perpetuated, that gets cycled through these systems, and it keeps going to the same places and disseminated by the same people. So why would they want that to change?
And fixing the problem of the social injustice and social inequity doesn't buy votes, but standing up there and saying, we're going to get tough on crime, buys votes and keeps people in.
Yeah, absolutely. And I think to sort of tie that discussion of power and hegemony to the court system, I think, one of the ways that we see that reflected is that we're using a system basically, grounded in tradition rather than the evidence base, to say that, we've inherited this system that came over with British law, this common law system where this process, this judge sort of proceeding over this trial with the jury, has been then implemented here in Australia, and we hold on to that, that, and that is steeped in that archaic sort of tradition of I guess white supremacy, because there's really limited First Nations representation in the judiciary. Whereas when we start to look at what would work in terms of a trial process or accessing justice for First Nations peoples, it leads us into an area that has to recognise and acknowledge First Nations culture and ways of doing justice differently, that perhaps are more circular, that are not as hierarchical in nature. So, everything not only procedurally, but physically and visibly within and architecturally within a court is very hierarchical. So, yes, I think the persistence with this way of doing justice through this trial process is very much reinforcing that power and is not then recognizing that that doesn't work and for everyone and disadvantages some people. So if we come back to your first point, Barty, about what your group discussed around socioeconomic, so we know that from a financial perspective that a trial process, to go through that and to defend oneself is costly, particularly with private legal representation. So people often then access legal aid. What do you think are some of the issues? Like, a legal aid is obviously a fantastic thing to have. available to people. But would you say that more pro bono, legal assistance is the same as private legal representation? And what might be some of the issues around legal aid?
Funding.
Yeah.
Not enough funding to provide the service adequately.
Yeah.
Yeah, just so many issues along the lines of funding that the help they're able to provide is limited. It can be geographically inaccessible.
Yes.
All sorts of things like that.
Yeah, resourcing, is the main issue there that you're talking about, is that, you have people with really high caseloads of clients that, it's just, and then doesn't mean that they're a bad legal practitioner. It's just that it's unreasonable to expect somebody to provide the highest quality of legal representation when you're trying to represent so many different people.
Absolutely. And timeframes come into that. Like, I've never been charged with anything criminal, but I've needed legal aid services for a couple of things in life.
Yeah.
And the couple of times that I've had interaction with them, their timeframes of how they can help you, when they can help you, and what they can do falls radically short of the time limits imposed on when you have to respond to things.
Yes, absolutely. Yep. Who was first, Talara or Craig? I don't remember.
With remand, the issue is that hopefully it doesn't interrupt me too much. But the remand system implies that they could get there in the first place to be able to be in that situation where they can have a defense.
Yes.
And so that means that they haven't pled guilty previously, because the remand system in itself, I mean, yeah, you were talking about length of time. You could be seeing someone in remand for 2 years. So they could be serving in remand for 2 years, completely be innocent and found out later, but they would have had to go through the whole jury system, everything else that happens, the whole wait back and the courts back and forth and everything that can happen. Turns out they were innocent, they get released, and then there's nothing. They've just wasted 2 years of their lives.
Yeah.
And then in some cases, they can plead guilty and be out in the same time period.
Yeah.
And all of a sudden, they don't have that same pressure. So
yeah, absolutely. I think one of the things that raises is when we start to look at plea bargaining, and it ties into that legal representation, because yes, for some people to be able to negotiate, so, for those that aren't aware, plea bargaining is a process that occurs behind closed doors, so to speak. It is a negotiation between the prosecution, defense, and the court regarding whether if the person were to plead guilty, they may get lesser charges. So there might be some charges that are dropped, and they may subsequently serve less time. So it is seen as favourable in the eyes of the court because it frees up that backlog. Now, of course, when we think about the fact that, well, can you think of the issues that might arise out of that? The point I'm trying to make is that someone can't fairly engage in that process of negotiation unless they have a legal representative to guide them to say, it is in your best interest to actually plead guilty and then get a lesser sentence. But is there any other due process right that stands out to you as sort of standing in the face of, flying in the face of, rather?
I think with the threat of being held in remand for a long time, and lest they negotiate, would force a lot of people to plead guilty to get out faster, even if they are innocent.
Yes. So this presumption of innocence until proven guilty, one of those due process rights then is undermined by that. We do see that there is a higher representation of ethnic minority and First Nations peoples that are in that situation that Natalie has just described, where they may be innocent, but the likelihood that they would be able to win a trial is highly unlikely. So they are advised to accept the bargain. And as Craig said, then the advantage then is you are directly sentenced, you're not on remand for long periods of time. It may be more cost effective for you. There's a whole raft of reasons why that might happen. And I think often people forget about that plea bargaining that can occur. And yeah, it's a really interesting area. So socioeconomic is a huge driver because, as I said, it's costly. Legal representation is critical, though, to people's ability to navigate the court system. Let's talk a little bit about that, navigating the court system. So what other challenges did you come up with. Thinking about perhaps the trial, the court setting. If anyone has been to court, feel free to share.
Language barriers for starters.
Yeah. Yeah. Very, very difficult for a layperson to understand, you know, even with some legal understanding, it is very, very difficult to, and sometimes very quick, fast-paced, like there's quick exchanges between people stopping and starting and people interjecting, and it's very hard to follow that and what's going on. So that can be very, very daunting. If someone was, say, asked something and culturally that language or that word meant something different, then they might respond in a different way that might be a disadvantage to them through, say, cross-examination. What else in terms of the court system?
It's isolating.
Yeah.
So, especially for First Nations who are highly collective and live collectivist lifestyle, so they consistently are surrounded by community.
Yeah.
And when we go into these sort of settings, it's extremely isolating. It's very confronting in terms of decor, environment, sound, smell. It's very unfamiliar.
Unfamiliar, intimidating is another word, yeah, that comes to my mind. Absolutely. And even, as I said before, the hierarchical or architectural organization and layout of a court is intimidating and reinforces that white supremacy and that colonial image of white superiority, because you have obviously predominantly white judiciary who are, and predominantly white staff. We'll talk about juries in a moment. So I obviously can't speak on behalf of, but can only imagine how intimidating that must be for a First Nations person presenting to court, which in and of itself is already stressful enough.
And on the remand note, am I correct in my understanding that a lot of people are in remand because they haven't met bail criteria? Like they either don't have the money for bail or they don't have a permanent home address, so they end up in remand for so many reasons.
Yeah. And they may not be able, they may not have someone who's able to make that case clearly for them, to say that, you know, no, there are plans in place. This is how we can assure you that, you know, things, that the person's not a flight risk in the community, so they're not going to take off somewhere else. Yes, and then there's a whole range of factors related to disadvantage and marginalisation, as you mentioned, not having a fixed address to which you must provide. So, you know, when we hear these discussions that are politically driven around youth crime, around violent crime, of let's bring in stricter bail laws, unfortunately, in Victoria is a prime example. We did that after a number of very high profile cases of violent crime committed by men. And the adverse effect of that was that women were remanded increasingly because they were more transient. They didn't, if it was, say, related to domestic and family violence, didn't have that address to go back to. Yeah, so a whole range of issues there to keep in mind with that discussion, which I know is probably, I think it may be happening at the moment in Queensland, if I'm not wrong, around, it's probably happening everywhere. It's happening down here again. Yeah. Any other challenges that we can think of?
Lack of mental health support.
Yep. Yep, absolutely. And culturally safe and appropriate support, victim support, support around mental health. We know acquired brain injury, you know, very high. So not only is there an issue with access to legal representation, but then we can look at the extent of the appropriateness of that for people's needs. Yeah. I think that covers quite a lot of them. And as I said, we'll hold off on the discussion of juries because we'll do that at the end. Historical and socioeconomic factors. We've got, obviously, you've talked about socioeconomic disadvantage. How do you think that, from a trauma-informed lens, how do you think that colonisation might feed into the experience of First Nations peoples with the British court system?
fear, bias.
Yep.
Yeah, I've gone blank. I had a couple of others, but gone blank.
Yeah, I think bias is a good one. And we haven't talked about that. So, if we think of the judiciary being predominantly white, male, well-educated, usually coming from upper class backgrounds, people are going to come to a trial and view a defendant with particular biases and prejudice. Yeah, absolutely. Even court staff may well, and that might impact the experience as well.
Fear and distrust from an trauma-informed. So
Yeah,
there's very little trust in the system because it's an oppressive system,
yeah,
because of the
And-
legacy of oppression.
exactly. Yeah, so that legacy, the intergenerational trauma, the stories that are passed on, would make it really difficult, and could potentially amplify people's behavior at trial, which is not going to lead to very favorable outcomes and impressions of them. So, what support is there in that sense? And obviously there are more culturally appropriate and safe ways of doing justice that we can look to, and we'll talk about those later in the unit. Yes, so I think all of those things, obviously we see there's a system that is working against First Nations peoples and not in their best interests. It begins with policing and all of the issues we looked at before the break and that overrepresentation. And then you've got here a process where, as we talked about on the previous slide, where there on paper are all these really great ideas about how people access a fair, equitable trial and access justice. And that is just not the case for First Nations communities. So anything else that anyone wants to add on that before we move forward? No, I think that we're pretty
The
much.
power imbalance.
Yes, absolutely. And so the literal power imbalance, but also I think at an emotional level of, that reinforcing of that power imbalance. And I think it's similar with the prison system, that unless people have been through that, then that can't be understood, so it's really that lived experience is really important. And you can imagine for young people as well, how that's amplified even further. So if you're a young Indigenous person who is charged with a criminal offence, these issues are going to be even worse. And so from intersectional perspective, I should also mention, it's not just about, okay, the defendant is a First Nations person, so that means that they're going to be disadvantaged. It's about the intersection of those other factors. So do they have a disability? What is their age? What is their location, for example? We know that courts operate differently in regional and remote communities than they do in metropolitan locations. Yeah, so a whole range of issues there. I'm just checking my... Yeah, cultural and language barriers, socioeconomic disadvantage, historical and intergenerational trauma, and underrepresentation on juries, which we are going to look at. Wow. Okay, so juries, really sort of a key hallmark of the criminal trial, unless it is determined to be a judge-led trial. Now, the point of juries is that it is a determination of guilt or innocence, so guilty or not guilty, made by your peers, which are supposed to be a cross-section of the community. We know that there is a process for jury selection where there's a certain amount of challenges that each side, each party can bring forward on certain grounds that they don't want that person to sit on the jury, and that's their chance to either, try to balance or unbalance the jury representation. What I want you to do, and we're going to use this as a bit of a practice or a checking point for your annotated bibliography. I would like you to jump onto Google or the CQU library database and research First Nations representation on juries. So the first challenge, I've had a go at it, the first challenge will be trying to find the right combination of search terms to hit on the literature for this topic. So we are talking about First Nations underrepresentation on juries in the criminal trial process. And I just want you to find 2 or 3 articles that seem to be relevant to this topic. And then with one of them, I want you to have a go at writing an annotation. So just around about 100, 150 words. You can write a little bit more if you have time. Depends how quickly you write, and bring the thoughts together. Now, don't stress. It's limited time to write it. And I know that writing skills don't come as easily to some people as they do to others. So this is not going to be necessarily a judgment on your spelling or your grammar or anything like that. But I would like, once it's done, for you to pop it into the chat. And then we'll have a go at just sharing, comparing, see what you interpret the purpose of the annotation to be. So I guess what I'm saying is, don't stress too much. If you don't get it absolutely right, then that's kind of the point of the activity, because then I can go, hey, this is how you could improve this for the assignment. So does that make sense to everyone? Researching it, find 2 or 3 articles, and then just select one of them and write one annotation for that article. Any questions before we go off and have a go at that? No? We might initially go for 15 minutes. Okay, so at that point, I'll check in and see if we've nearly finished. If you finish before then, just chuck your annotation into the chat. It should let you paste more than 100 words, but if not, just break it up over 2. So, you know, I might like to open a Word document. So you can also save it there. All right, I'll leave you to it. I'll turn off the recording and I'll see you back at 1:15. Okay, so for those that are listening at home, the activity was to research First Nations representation on juries and find 2 or 3 articles of relevance. So I guess the first point is in the search terms. Did anyone find it a little bit tricky at all to find articles, and how did you overcome that with your search terms?
Google Scholar helped me find articles faster than the library, because the library you have to get so specific with your Booleans and search through so much stuff.
Yeah.
So I found a bit on Google Scholar.
Yeah.
But yeah, putting things, I can empathize with Craig. For me to try and craft things in words rather than just a few dot point ideas takes me a long time.
That's fine. That's no pressure at all. That's okay. And I appreciate that. It's just to see if you're on the right track, and I think you've done a fine job with what you've written down there, Natalie. Yes, Google Scholar can sometimes be a lot quicker, and the CQU library database will require some editing of the search terms. I know when I looked it up, I had to sort of keep extending the search terms that I put in. So that's something to keep in mind for not only the annotation or any research that you do, really, is that it does take quite a bit of time to locate articles. Craig?
I was just going to say with that, I actually commonly find things that just simply don't exist on the CQ library. I've found actually in quite a few of my assignments I've done so far, the perfect, like, just a really good research, a study, well published on stuff that we have access to, but CQ just literally, I can type in the exact name of the thing with all the Booleans. It literally just does not exist for CQ. Even on, I accessed it through CQU's library access, because you have to add Google to your CQU to your Google Scholar, otherwise it doesn't work as well. And it just simply doesn't exist. The CQU library is truly garbage. Sorry, but that is, I've heard that from other people that are on staff, that I'm not allowed to say the name obviously for it, but they will agree that it is absolutely garbage. And anyone that's using it, like, I only use it for references if I absolutely have to.
Yeah,
so
it is.
I found 2 articles, but I approach it difficultly because of the equal representation. It also, so can I say with this my like thoughts behind it? So with the jury situation at the moment within Australia, I definitely agree that there should be some representation. However, we've also got to refer back to the notion of the percentage of the population system. And in us selecting someone based on their skin color, that in itself is a bias and a racism component. So you've got to play it so carefully that you can't just say, well, that person is the same, cultural background as another person, so therefore we select them because of that. That's in itself is a bias, because the idea is that the judicial system is meant to be free of biases. It's meant to be, I'm not saying it's perfect, definitely not, but when you infer and change on those components, you then introduce new biases that can't be as easily checked, if that makes sense, rather than just selecting random people. However, I know that there's a lot of issues with it already.
I hear what you're saying. Yeah, I hear what you're saying. I guess the counter argument to that would be that if it is supposed to be a representation of your peers and your community, what do we mean by community? Because for First Nations peoples, that's going to be a very specific group of people that most juries, if we're basing it on the representation in the broader community, so if you say like 1 to 2% of people in the broader community, or 1 to 3% are Indigenous or First Nations, Aboriginal and Torres Strait Islander in Australia, then the majority of the other people on that jury are not going to necessarily be community for that individual defendant. They will represent the community more broadly. So I guess it's depending on what definition of community and what definition of peers are we adopting there. Are we adopting, as you said, and I think this is actually kind of the argument, yes, around equality, equity. So equity is obviously meeting the needs of the individual. Equality is equal for everyone. So I think the first argument that you made, Craig, about representation of the broader community is really that equality, so that every single person is judged on the same sort of jury of the same composition. Whereas equity for a First Nations person would be that they're tried by their peers from their community. Yeah. It's interesting to think about those two concepts and the disadvantage of equality. And that's where sort of around gender equality, that's where we started, was let's just reach equality first. But equity is far more beneficial in meeting individual needs and responding to individual circumstances. So if we think about a jury that is predominantly white, would not understand necessarily the background, well, not necessarily, they wouldn't understand the context, the background, the circumstances, the trauma, all of those things for an Indigenous defendant. All right, let's have a look, because I do have a video I want to show you really quickly to end the shoot. Let's have a look at the examples of the annotation. And there's another one from Julia. Thank you, Julia, for popping that in the chat. I'll just quickly read yours.
I will just say,
Yes.
I got pretty lucky. I actually found my source with CQU library.
Yeah.
And it showed me it could be referenced in many ways, and one of them was for the APA 7th edition.
Yes.
So I just kind of edited to that. So yeah, because I've never done an annotation before. So
okay, yeah, beautiful. That's the quickest way to get the citation and formatted pretty accurately. I use it all the time in that way for my own work. So for anyone that doesn't know, when you do find your article, there's the little cite button and you can choose Harvard, APA, all the different formats, and it will generate it mostly accurately for you. You might need to do a little bit of editing, but yes, that is the quickest way. So thank you for raising that point, Julia. And it does look beautiful there in the in the post. I think what I would say about all of them is, and this is probably the time constraint as well, because one of the things with the annotation, and actually it's a really brilliant point now that this turned out much better than I thought it would. It's a really brilliant point to make about the annotation, is that it does take time and it does take reflection, because what we see in the 3 examples that are posted are really fantastic descriptive overviews of the content that's in the article. So they tell the reader what the key highlights from a sort of content perspective are. So for example, with Vayardes, it talks about the evolution of jury trials in Northern Canada. It highlights how Indigenous people have been treated historically and their representation or lack thereof on juries. And then you go through chronologically what they talk about in the article and sort of the cliff notes of in the 60s, in the 80s, and some recent changes to legislation, challenges still remain. So you're able to summarize from a descriptive perspective what's in the article. And similarly, Natalie, that's what yours does, and as does Julia's. The difference with an annotation, and particularly for the purposes that we're doing it for this task, is to move beyond the description of the content to more of an appraisal and reflection on the piece. So there are numerous ways that you can tackle that. You could look at, for example, location, and you could say that this particular piece of research is really useful for understanding, for example, the first one with Vayati, representation of juries in the Northwest Territories, Northern Canada. However, the Australian context may be different and there may be nuances. The article would therefore be limited in its applicability to the Australian context. However, there may be elements of the Canadian experience that could be translated. So what you're doing is you're saying, right, this is my topic that I'm choosing for my research paper. Now, here are a number of articles, and this is what they're this is what they offer me or don't offer me in terms of answering that question. So we're looking for, yes, a little bit of description, but also balance that with appraisal and reflection on the piece. Yes, Craig, is it a justification of why it can or can't work in your assignment? Yes. So you think of it as your evidence of your research process, and that's why I've put it in, because AI use is obviously becoming very prominent. The risk of just having a research essay is that a whole bunch of students will just AI generate their research essay. And when it comes time for me to look at that, how do I know that you've actually done that research yourself? So think of it in that way. This is your building evidence of your research process, your process of selecting and appraising sources for your essay. We appraise them in terms of the relevance of the information, the timeliness of the information, the proximity to where we are located or where the research topic is located in Australia. We can look at their political persuasion, whether they have a particular methodological preference. They might have adopted a quantitative analysis, and therefore there might be some gaps that maybe a qualitative analysis would have offered, those sorts of things. There's a bit of a balancing act between description and appraisal. Does that help with the assignment? And are there any questions?
So just for clarity,
yeah.
So the emphasis is on reflection and appraisal, but it's got to have descriptive as well.
Yeah, so they're interwoven. So you might start by describing, but then you would shift to, like, because that is the focus, these may be the things that are missing. Or this is the focus of it, this is what it covers. It did that from this particular methodological perspective, and because of that, it is useful. Yeah, so it's very much it's basically not a retelling. So for example, if you looked at an article and you were just describing the content, you could literally just rewrite the abstract of an article, and that could be your annotation. In order to understand what the strengths and limitations of the piece are, and often the author will themselves, they will admit what they are, because that is a key criteria when we submit for publication. You appraise your own work and you acknowledge, a good article will acknowledge the limitations of the work. So you would need to read through the article to find those things, or to appraise them yourself. So I think that's the difference, is that those students who have gone to that effort to actually read the article, to reflect on it, to think about how it connects to the essay question, that will show in your annotation compared to someone who has just rewritten the abstract. Sabrina?
I've done a annotation before.
Mm-hmm.
Would it be all right if I sent that through, like just like a little bit of what I've written to help people? Yeah.
Yeah.
To better
Absolutely.
understand what it is, because I got quite a high mark for it. So
yeah, Go for it. Absolutely.
Yes,
And
please, and thank you.
yes, I don't think anyone's going to say no to that offer, Sabrina. The other thing, just while Sabrina is, are you going to pop it in the chat?
Yeah, I'll pop it in the chat, just one of the ones that I've written up.
Wonderful. One of the other things that I will mention is, and I'm going to just check that I'm not wrong. Where are we? Yes, there is an assessment overview video in the assessment area, and it makes reference to a number of online sources of information about annotations. So I'll just quickly find those for you. Annotation, custody, so the Australian context there is a lot of international literature, but please make sure that with all of these topics, they are focused on the Australian context. Sorry, I was just reading your thing, and then I was like, who's that voice? And I was like, oh, that's my voice. Yes.
Can I ask, what's the difference between annotation and analysis? I'm getting confused there.
What do you mean of analysis?
So rather than writing, so an analysis would be looking at the analyzing the you would look at the strengths and weaknesses. Is that similar to annotation?
Yeah, it's similar. And annotation is just an annotated bibliography is a particular thing. It's like an annotation has a definition of what an annotation is. So I might just quickly, that is a good example as well. Thank you, Sabrina, for that. And you can see the difference in the response around the appraisal of the source. Let me just mute this video and I'll skip to the, just for those that haven't watched it already. Okay, so I go through the topics that you can choose, the task. Here we go. Okay. Let me just share screen. If you haven't watched it, I really strongly encourage you to watch it. Okay, can everyone see that? Yeah. So I go through what annotation is, and there is a lot of examples out there around how to do an annotation and annotated bibliography. Brief overview of the source. Often people will look at the author as well, where they come from, their background, how or why the source was written, the accuracy of it, any biases that it might show, anything that it doesn't address, elements that are particularly useful. So if there's particular statistics, graphs, charts, concepts that you would take from that for your assignment, you would mention those, your personal views on the source. So it is, I think a good way to think about it is a little bit like, you know, in primary school, for those that have done a book review, it's a little bit like a book review. So for the kids that never read the book, they just either watched the movie and wrote what the movie was about. My husband did that. He's like, yeah, I said, didn't you watch Romeo and Juliet and like read the book and that? And he's like, I watched the movie, the modern one, and I just wrote my assignment on that. And then, anyway, I was like, oh, goodness me. So, Vayati, you put your hand up as well. I was always the little nerd burglar that like read the book 3 times and then cross-checked with the movie. Anyway, so make sure that you just don't rewrite. Oops, where are we? Stop share. That you don't rewrite the abstract. I'm sure all of you here won't. I'm sure Vayadi, you're past that phase of just watching the movie. Although I have to say, I just started reading It Ends With Us, and I'm only a little the way in, and I went and saw the movie. And I was like, I don't bother reading the rest of it. I just want to see the movie, which is absolutely fabulous in my opinion. Yes, it is a good one. Anyway, we're getting off track. I am getting off track. Any other questions about the annotation? So some of the issues, let's come back to the topic. Some of the issues that you picked up in your description. Slides here. We've got barriers to being on a jury. Prior criminal records is one of the ones that stands out from Natalie's response. Disability, caregiving roles. So obviously for people that experience those things, which we know are much higher in First Nations communities, you're going to have grounds for your GP, for example, to say that you don't have to serve on a jury. And then you are not ever called up again. I have done that for myself on the grounds of disability. And it says, you know, we will not contact you again about this.
I'm pretty certain you have to enroll to vote in order to be able to serve on a jury. Is that correct? You can't just be a
Most
citizen in
likely.
Australia.
Yeah, electoral
And
enrollment.
one of the articles I found just before showcased how there's an overrepresentation of Indigenous Australians who are not enrolled to vote. They are 17% of the unenrolled vote in Australia. So that's a huge amount of people that can't actually serve in a jury based on the fact that they're not enrolled to vote.
There you go.
So, and I think that may also be because once you enroll to vote, if you fail to vote, there's a fine within most states of Australia. So, you know, they may want not to do it because they might not want to have an opinion on the voting system or don't want to engage in it, because if they don't, they'd get a fine. So it's like, okay, well, you know, maybe there needs to be a change to the way the system works for that.
Yes. Change to many systems, I think, is it's kind of cliff notes for the unit, isn't it? Just burn everything down and start again. So I think, you know, looking at, just to summarize, you know, obviously, as we mentioned before, that is it really fair then if it's not representative of community for First Nations peoples? Is it really fair? You know, is it upholding that due process right to be tried by one's peers? You know, unlikely not. Another, you found that one, the Blinded by the White, very creative title. I love a creative title on an article, by Talia Anthony and Longman. I don't know who that is. That talks about a sort of what I'm saying, cross-cultural, cross-comparative analysis. Indigenous people in Australia, US and Canada, overrepresented as defendants in criminal trials, yet vastly underrepresented on juries. They look at the ways in which Indigenous defendants have perceived that an all-white jury's prejudice against Indigenous people would prevent them from receiving a fair trial. It focuses on Indigenous defendants often facing charges in relation to protesting against white racism. That's interesting. Challenging the array of all white juries. So I think that is really, like, if you were looking at that obviously lived experience, qualitative engagement with community would be a real strength of that article. That stood out to me, that article. All right. And thank you, Sabrina, for the example. Maybe pop up, if you're happy to pop it on the Teams as well, because people listening at home cannot see this. Moving forward, so that's the annotation. What I want to quickly show you now as we finish up is just an example, a real world example of the issues that we've been talking about. So I'm going to play a video. I won't play, it goes for 20 minutes. I won't play the whole 20 minutes. I just want to play you part of that video to get a sense of some of the issues. And it's also a case, if you may have heard of the case before. Let me pull it up. Is that the right one? I'm just checking. Yes, Jean Gibson, who was accused of killing Josh Wernicke in WA, and it's a really seminal trial or example of the issues. So let me share with sound, and we'll do this to finish up. Go back to the right spot.
Domino's has flipped the burger world. Classic recipes, authentic ingredients, now available as pizzas.
Looking in that direction, making his way home.
Okay, so they'll talk a little bit about the case. But what I want to focus on, the start of it was around introducing his mother. So when you see the woman with the dark brown hair, that's the young man who passed away, that's his mother, talking about what happened at the trial. All right, here we go.
Minutes later,
You can hear
he
that?
was dead. And after 6 years, how he died and who really killed him remains a mystery. Right from the start, the police investigation was either lazy or incompetent, or both. It dragged on and on without progress until August 2012, when police arrested 21-year-old Gene Gibson. Not only did investigators claim he'd confessed to killing Josh Warneke, they also boasted they had substantial other evidence to support their case.
Why do you think Gene is innocent?
Firstly, forensics don't stack up. The forensics paint a very different picture to the story that Gene Gibson has told or was coerced to tell. There is no doubt that he was coerced.
Ingrid has spent countless hours sifting through the case. She's convinced police have the wrong man. The evidence against Gibson is flawed. And most damning, his confession about how he killed Josh is nonsense. First, he told police he ran Josh over in the car, but the forensic evidence made that impossible. Then Gibson admitted to hitting Josh with a rock, but again, the evidence just didn't match up. Finally, he told police he'd hit Josh 3 times with a round metal pole that he found at the base of this tree. He was pretty sure about that because it was in front of this house. Problem is, this house hadn't been built at the time Josh was murdered. And it gets worse. Despite apparently admitting to the killing, Gibson couldn't remember where it actually took place. He also says Josh was wearing a shirt when he wasn't.
No, he had no shirt on. His shirt was tucked down the back of his shorts. It was a hot night, very hot night, warm nights in Broome.
Former Broome taxi driver and paramedic Jim McCall was the first person to discover Josh's body.
He was without a shirt on, so you could actually see if he had been hit by a car. There was no sign of any bruising whatsoever. No tread marks or anything like that.
Jim McCall's account also exposes more holes in Gibson's so-called confession.
He was lying basically outwards towards the road, so basically from there looking out towards the road.
Perpendicular.
Yep, perpendicular road.
See, it's interesting because Gene Gibson told police that he was lying this way.
This way?
Parallel.
No.
That's not right.
No. Definitely not right. It's definitely perpendicular.
When Josh's body was examined, a clump of hair was found clenched in one of his hands. It was sent to the Australian Federal Police Laboratory in Canberra for analysis. The police here didn't wait for the results. They charged Gibson with murder anyway. But incredibly, the AFP found those hairs had been cut through by a sharp object, like an axe or a tomahawk. This explosive evidence directly challenged Gene Gibson's story that he'd killed Josh with a round metal pole. Forensics proved it was a weapon with a sharp edge. That's also what eyewitness Jim McCall told police. As a paramedic, was it clear to you what could have caused his death?
Well, I gave the opinion to the police when I first talked to them that he was hit on the head with an axe or a machete. So when I looked at it, there's a couple of gashes down there.
So, Gene Gibson's story is he hit him with a round metal pole. You don't think that's possible, do you?
No. Definitely not.
But the police were convinced that in Gene Gibson, they had their man. And from that point, this poorly educated Aboriginal man never stood a chance.
I think that would be a very scary situation for Gene.
Gibson is from Kuakura, Australia's most remote community. Both his parents were alcoholics. His father died when he was very young. When the police first went to Gibson, they questioned him for 9 hours. But they didn't record it as demanded by law. It wasn't voluntary, and they didn't bother to get an interpreter. You see, Gibson can barely speak or understand English.
I believe that Gene Gibson does not understand the full extent of what all the conversations were. There's a strong suggestion to say that he has fetal alcohol spectrum disorder. So obviously he's got some significant health and wellbeing issues.
In August 2014, Gibson was supposed to stand trial for murder. But in a blow for police, a Supreme Court judge ruled the confession was so dodgy it couldn't be used. As a result, the murder charge was dropped, and in a deal, Gibson agreed to plead guilty to the lesser offence of manslaughter.
People absolutely plead guilty to something that they didn't do. It's a value judgment they make, especially when the stakes are very high and they don't want to bet that much on their future.
Prominent criminal lawyer and Queen's counsel Tom Percy is not surprised that Gibson accepted the plea deal.
It's a very big decision to make. You go and you're betting a life sentence against a 7-year sentence that you'll be believed by potentially a jury panel which come from a completely different ethnic background to you.
All white.
Yeah, and and there's often a prejudice in a courtroom where the average juror thinks, well, he wouldn't be here if he wasn't guilty, would he?
You think it would have been daunting for him to face a murder trial?
Oh, look, he was an accident waiting to happen in the witness box, I would have thought. And if you're not particularly articulate in the witness box, you can be in a lot of trouble.
Gibson has now been behind bars for 4 years, but it hasn't been the end of the matter, because the rest of the police case has come under increased scrutiny. The case is now collapsing as new evidence comes to light.
With no confession, police were left with just 2 witnesses, 2 men who say they were with Jean Gibson that night. Originally, they insisted nothing happened, but after hours of police interrogation, they agreed, yes, Jean Gibson probably did it. Well, 2 years later, those men have been re-interviewed, and guess what? They have now gone back to their original story and say Jean Gibson is not a killer.
The 2 key witnesses, Tristan Nagamara and Edwin Mandajara, live in the remote Kimberley community of Balgo. We tracked them down to do separate interviews and made sure we had an interpreter present.
Okay, so let's start at the beginning.
It was their incriminating statements that put Gibson in jail.
I was frightened. Yes, I was frightened.
But tonight, the young men want to put the record straight.
Why did you tell the police that Jean Gibson killed Josh?
Because the coppers, that was like threatening me. I thought I was gonna go to prison too. The detectives told me that he did it, and I didn't know where I was standing then, so I had to point the finger at him because I knew they were gonna pin someone. But I don't know who.
On you?
Yeah, they were gonna pin someone, like they were pushing me in to say that he did it.
When you found out that Jean had pleaded guilty to manslaughter, what did you think then?
I've asked the Lord to forgive me for what I did, and because I lied, because I know he didn't do it.
It was part of your statement.
Yep.
That put him in that spot.
Yeah.
That's put him in jail. And is that why you feel guilty?
Yeah, that's why I feel guilty, and I felt ashamed of myself, and most of his family are here.
The men admit to being with Jean Gibson in a stolen car the night Josh Warnicki was killed, but say their friend was not involved.
Did Jean Gibson hit anybody that night?
No.
Did he hit a white boy?
No.
Do you think Jean is a killer?
I don't think he's a killer. He's just a kid,
Do you know who killed Josh Warnicki?
I don't know who killed Josh Warnicki.
In Jean Gibson's case, the only reason he came to the attention of police because he was, he happened to be in a stolen car. And from there, it's escalated, hasn't it?
You find someone in the wrong place at the wrong time, in the wrong circumstances, quite often they will be a subject of investigation, and sometimes police feel some pressure on them to get a suspect and start moving in that direction. And then, unfortunately, sometimes the blinkers go on and they don't want to look outside their line of inquiry.
Do you think that's what's happened in Jean Gibson's case?
I think almost certainly that's happened.
Okay, so a perfect example there of everything that we've just been talking about. one of the key issues that we saw in the video was the acceptance of the plea bargain. And I mean, any thoughts, any reflections? Does it sort of bring the issues to life for you that we've been talking about and how they might play out?
Language barriers, fear of having it pinned on themselves. You know, someone was going to be blamed, whether they were innocent or guilty. And yeah. Police corruption, laziness, bias.
Absolutely. And I think the point that the criminal defense lawyer made about if you're staring down the barrel of potentially life, if you can't win that case versus 7 years, and that bargain looks very, very appealing. And I think we often forget about that, the fact that particularly when we talk about corrections and prisons, and people tend to get quite punitive about prisons, and it's the assumption that everybody that's in there is a criminal and the worst of the worst. And there are many innocent people. You probably heard the saying, there are many innocent people in jail, and it's often said because most people in jail will say that they are innocent, but literally there are people in prisons that are completely innocent because they've accepted a plea bargain or because they've faced an unfair trial, and then they languish in that setting and are punished. So I just wanted to show you that to give you an example of how this happens. And the tie to police for you is also the fact that there is the role of police prosecutors, and police on behalf of the state compile a brief of evidence around the investigation that they have conducted. And that obviously has a lot of input into then the prosecution of the defendant. Interestingly, down here in Victoria, I was dabbling a little bit in some research about that. It never really took off much, but one of the things that we found was that police prosecutors don't have the same legal training as other legal practitioners. It's just a brief course that they have to do, so they are not fully legally trained to the same extent. They obviously come from a particular culture with certain biases, yet they are in court presenting this evidence of their investigation, and which in and of itself may be flawed. There's a whole lot of issues around investigations. And then, yes, responsible for prosecuting the same people that they arrested. And obviously there's a big vested interest for police in a successful outcome for them, which would be a verdict of guilty.
Could you put a link for that video, please, in the chat? Because I have a couple of people that I'd like to show that to.
Sure.
Thank you.
You're welcome.
You thought you knew who killed your son.
It's quite a good segment. If you wanted other ones, there's probably other videos out there on the case, but there you go. Hopefully that comes up. Okay. We might leave it there for today. Thank you so much to the 5 of you for coming along, and to those listening along. I'm sure that you found it really useful. Next week, we will continue to talk about the assignment that's due the week after, and we might also start chatting about the research essay. Okay. All right, I'm going to turn off the recording now.